Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Mr. Burmeister, we're here today for sentencing on this case. So let me ask you, have you had plenty of time to speak with Mr. Coyle about everything that's in your pre-sentence report? Do you understand everything that's going on today and do you want to? Yes. Okay. I'm going to ask a series of questions. Any of those questions that are directed toward you, Mr. Coyle can answer for you. If you want to speak up, you may do so, and you will have an opportunity to address me before I sentence you. Okay. All right. Let me just get the terms on the record. The defendant pled no contest on March 13th, 2024 to count 4, which is and count 5, both of which are criminal sexual conduct second degree due to the relationship. At the sentencing today, counts 1 through 3 will be dismissed, and that there was a sentence agreement to 5 years probation with no upfront jail or prison. So that's where we are today. Counsel, is that accurate?
That is correct, Your Honor.
Yes, Your Honor. Okay. I've had a chance to go over the pre-sentence report, and you know from last week, also the victim impact written statement. And so I've gone over that. I'm going to hear from the two attorneys on their scoring of the sentencing guidelines. I've done some scoring myself. That all becomes part of the calculation of the sentence. And we'll get to that in just a minute. So before we do, I want to take a look at the informational part of the report. Mr. Coyle, do you have any additions, corrections, or deletions to the informational part of the report? I've corrected the date of sentencing on the face page, but anything else in that?
Your Honor, Mr. Burmeister and I have gone over the pre-sentence report, and regarding its contents, we have no additions, corrections, or deletions.
Willenbring, how about you?
I do not, Your Honor. One thing I will state for the record is that we would like to read the victim impact statement into the record. So whenever Your Honor deems the appropriate time for that.
I'll be back to you in just a minute. Okay. Let's talk about the guidelines. Any challenge to those calculations, counsel?
So I'd ask, I have no objection to the scoring of the prior record variables scores. I would ask the court to consider the following. Offense variable 3 is scored at 5 points, and those 5 points are scored for bodily injury. I would suggest to the court that there was no bodily injury and it should be scored at 0.
Okay. Anything else?
Additionally, yes, offense variable 11 is currently scored at 25 points, and I would argue to the court that it should be scored at 0 points. In OV11, it states that all sexual penetrations of the sentencing offense arising out of the sentencing offense should be scored with regard to OV11. And the sentencing offenses here, of course, are criminal sexual conduct in the second degree, where there was no penetration, or there would be no penetration. So I believe the scoring of that variable should be 0.
Okay, Ms. Willenbring, your response on, let's go with OV3 first.
As to OV3, it's a relatively low standard for bodily injury not requiring medical treatment. I do think that there was establishment of some physical bodily injury. So I would ask. Yeah, and she also mentioned that there was bleeding afterwards. So I do think OV3 is appropriately scored at 5. As to OV11, we did use the facts of the higher charge of CSC 1, and it is arising out of the sentencing offense. So I do think we can count 1 like in time penetration. So I think that is also appropriately scored at 25.
You know, it's interesting. So as far as OV3 is, or OV3 is concerned, when I looked at that, I obviously read the probation pre-sentence interview report and then the victim impact statement. I may be erroneous in this calculation, but I would think that the term sexual assault connotes some sort of injury potentially, and she does. And so I had that at 5. I didn't make any change there. On the OV11, again, the counts that were dismissed, of course, 1, 2, and 3 are in the first degree. And, I've always read that that's in the conduct of. So at this time, I've told counsel at the bench that I'm, tipping my head, I'm going to follow the sentence agreement, but I don't find there are grounds to change the calculation submitted by MDOC. So I do find that those are appropriate forward. Now to you, Ms. Willenbring, in addition to reading or having read into the record the statement of the victim, is there anything you want to comment as it relates to the probation recommendations sentence?
Not much, Your Honor. I would ask that you follow the recommendation. I spoke with the victim in depth prior to making this agreement and was in discussions with Mr. Coyle for some time about them, and he believes that this is an appropriate and just resolution of this case. Okay.
Are you going to read the statement, or do you have someone from your office reading that?
Ms. Schneider, our victim advocate, will read that into the record.
Okay, go ahead.
Good afternoon. To whom it may concern, it's very difficult for me to express and explain how the years of abuse that I suffered affected my life. The reality is that I will never know who I am without this abuse. The abuse that I suffered from my brother is one of the earliest memories I have. It wasn't until I reached 9 or 10 years old that I began to process the effect this abuse has had on me. For many years, I blamed myself and felt disgusted with myself because of it. To this day, the abuse I suffered from my brother affects me in nearly every area of my life. But I am thankful to say that through therapy and personal work, I am beginning to heal. More than anything, I filed this report because I don't want what happened to me to happen to anyone else. I felt responsible for making sure that my brother was held accountable for his actions in the hope that they would not happen again to anyone else. I love my brother and always will, but that doesn't make what he did right. I feel a sense of closure as this case is coming to an end, and I feel ready to wash my hands of the whole situation. I will no longer feel responsible if something happens in the future, and for that I am grateful. I am going to include a bullet point list of some of the ways that this has affected me rather than putting it in sentence form. I do not know what I would be like if I had not been in trauma mode since a very young age. I do not know what my personality would be like without this trauma, which led me to being anxious, controlling, realistic, negative, shame-filled, felt gross, and still struggle with this. To be happy, I've always needed to disassociate from reality. All I wanted was love and attention. Sam took advantage of that. I've walked through life with PTSD. It impacted my relationships in a negative way. At church, my parents, marriage, struggled with the idea of having a son due to the negative message of boys and men from the trauma. High levels of dissociation, depersonalization, derealization. When hurt, I would not feel pain. Significant distress during child abuse, childbirth, and after due to not being in control of my own body. Filing this report was not easy. It was one of the hardest things I have ever done. However, what is right is often not easy, but I am thankful I chose to file, and now I am confident no one else will be hurt. Thank you for your time, Leah Burmeister.
Thank you, and thank you to Ms. Burmeister. Okay. Bill, do you have any comment on probation's recommendations as far as their sentence conditions and or allocution on behalf of your client?
I do, Your Honor. First, I am standing here also asking you to adopt our sentence agreement for the following reason. As you can see from reading the pre-sentence report and hearing from Ms. Burmeister, this is very unique circumstances. And the circumstances are unique because of this. This is an incident that happened 20 years ago. And it's also a time that I dare say when the justice system somewhat fails all of us. And what I mean by that is, had charges been brought at the time this happened, we all know that Mr. Burmeister would be charged as a juvenile, more than likely. The consequences would have been different. The sentence structure would have been different, and the effect of his future would have been much different. However, the justice system fails because not that it's failing because there's no statute of limitations with regard to criminal sexual conduct in the first degree, but it fails with regard at the time in which it happened. And we were able to work this agreement out with the prosecutor's office, I strongly believe, because of that. And we had to jump through a lot of legal hurdles to get here. For example, we had to waive the statute of limitations to find ourselves before you on the offense which he is being sentenced to. So standing before you is an entirely different person. Mr. Burmeister is successful by every stretch of the imagination. This was a terrible mistake made, or a terrible decision that was made 20 years ago when he was young and his sister was young. So I'm hoping that this court sees that as I do and agrees that we have come to the appropriate decision in this case, or the appropriate resolution in this case. And I ask that you adopt our sentence agreement. I did say at the bench, and I will say here, I know that the recommendation by the probation department was for 1 year in the Washtenaw County Jail. I'm asking you to not follow that recommendation, follow our sentence agreement, of course. But should this court feel that any jail time would be appropriate, I believe the appropriate measure would be to put that at the back end of the probation. And if Mr. Burmeister successfully completes the probation, which I know he will, that time need not be served. Thank you.
Okay, thank you. Mr. Burmeister, is there anything you want to say before I impose that?
No, I guess that I agree with my lawyer. It happened 20 plus years ago. I have done a lot to be a different person, and I just want now to be present, to be able to take care of my 4 children and my wife, be present in their life, and to take care of them as the future goes forward.
Okay. I'm sure your lawyer has gone over this with you, but I have like 4 things that I consider when I sentence anyone. One is punishment, one is rehabilitation, one is protection of society, and the other is deterrence. I tend to focus on the 2 in the middle. It's a lot of punishment, regardless whatever I do. This is the punishment. And jail is certainly more of a punishment, but it is nonetheless, the whole process can be that. I'm guessing because of your criminal history, deterrence is not such an issue for me, in the sense that my actions today would deter you from future activity that's against the law, and or my actions today would deter society, other people, from breaking the law. I think I'll take at face value what your attorney has said and what you've echoed, that you've done work 20 years to kind of make changes in your life to not be room again. So that turns us to the middle 2 issues. Rehabilitation. I do think that you have had an opportunity to work on that. And I, again, take at face value yours and your attorney's statements that you've addressed these issues, and that you are working to do what you need to do to make sure that this kind of thing doesn't happen. I appreciate your sort of putting out there that you want to be there to provide for, to be part of your family, and I commend you for that. But remember, as you well know, your sister is your family too, and that does lead us here today. So, my expectation is that you do follow the recommendations of probation and any of the programming that probation provides, whether you think it's necessary or effective or not. You're going to complete it. I would ask you to keep an open mind in terms of, as you process this and its effect in your life, that you continue whatever you're doing in terms of mental health therapy, whatever that is, because for you to be, I think, a good and whole father to your children, this needs to be something that you attend to probably for the rest of your life. So I'm going to encourage that beyond the probation requirements, that you in fact care for this, so that you can be there for your family as you've expressed. The rest is the final thing is protection of society. And, you know, again, if I had the thought based on other activities or other complaints about you that you were a threat to society, we wouldn't probably be having this conversation right now. You would probably be incarcerated for more than the 1 year in the Washington County Jail. And so, you know, I'm going to take at face value what your lawyer has advocated for you and what you've acknowledged as well, is that you regret this and that you are taking whatever measures are possible for you so that this isn't a concern for me going forward. So based on that, for count 4, criminal sexual conduct in the second degree, i.e. that is in a relationship to the victim, it is the sentence of the court that you be sentenced to probation for a term of 5 years, subject to the following special conditions. And in this case, the guideline sentencing recommendations remain at, through the discussion of calculation, 43 to 86 months. Condition number 1, you must not have verbal, written, electronic, or physical contact with any individual age 17 or under, or attempt to do so either directly or through another person unless you are with an adult responsible for that individual and have first obtained written permission from the field agent. That, obviously, if you have 4 children, I'm guessing they're all under 17. So you're going to need to address that with the field agent. That's not going to be a prohibition of you seeing your children, but it is going to be complicated for you if your kids have friends over. So you're going to need to be thinking about that. Number 2, you must complete sexual abuse prevention programming or other treatment when you are referred by the field agent. Number 3, you must not reside, work, or loiter within a student safety zone as defined within 1,000 feet of school property, developmental kindergarten through 12th grade school, unless you meet statutory exemption. Number 4, you must register as required by the Michigan Sex Offenders Registration Act and comply with all the requirements of that act. You must provide a completed copy of the Michigan Sex Offender Registration Form to your field agent on your first in-person report following vacating your residence. Any address change, address verification, or change in your status with an institution of higher education. At each address change or verification period, you must present your Michigan operator's license, chauffeur's license, or personal identification card to the field agent at your first person contact. Number 5, to facilitate sexual offense caseload management team, CMT meetings, you must waive confidentiality and allow the disclosure and exchange of information between the Michigan Department of Corrections, including its authorized agents and all CMT members. Number 6, you must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first written permission for your employment at a specific location. Number 7, you must not use or possess any controlled substances or drug paraphernalia, unless prescribed for you by a licensed physician or be with anyone you know to possess these items. Number 8, you must not have verbal, written, electronic, or physical contact Leah Burmeister, directly or through another person. You must not be within 500 feet of their residence, school, or place of employment. So I'm just going to look at you and say that's also something you're going to need to discuss at length with your field agent, given the fact that she is in the family and we could inadvertently be within 500 feet of her if she were visiting another family member or you were. So you're going to need to be very attuned to that. And if some event happens, you're going to want to let the field agent know that before someone else does, because you don't want a situation where you're violating this because of that. Number 9, you must possess either a valid state of Michigan driver's license or personal identification card issued by the Michigan Secretary of State. Number 10, you must not engage in any assaultive, abusive, threatening, or intimidating behavior. Number 11, you must contact a supervising field agent no later than the first business day following your placement on probation or release from jail. Number 12, you must comply with written or verbal orders made by the field agent. Number 13, you must allow the field agent into your residence at any time for probation supervision. Number 14, you must submit to a search of your person and property, including but not limited to your vehicle, residence, and computer without the need of a warrant if the field agent has reasonable cause to believe you have items which violate the conditions of your probation. Number 15, you must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. I am striking condition 16. Number 17, a crime with $130 is ordered by the court. Number 18, pursuant to statute, you must pay a $30 supervision fee for each month of supervision or $60 per month for each month of supervision when being supervised with an electronic monitoring device. If you were to move to another state and be supervised for these counts in another state, you would not be required to also pay supervision in Michigan. Number 19, you must pay court costs in the amount of $1,611 as ordered by the court. Number 20, you must comply with DNA testing and pay a $60 fee as ordered by the court. Number 21, you must pay a $68 state cost as ordered by the court. Number 22, you must not use any object as a weapon. You must not own, use, or have under your control or area of control a weapon of any type or any imitation of a weapon. You must not be in the company of anyone you know to possess these items. You must not own or possess a weapon of any type or any imitation thereof, any ammunition or any firearm components. Number 23, this sort of modifies the earlier condition, no contact with any minor children under the age of 18, with the exception of your biological. Count 5 is criminal sexual conduct in the second degree, that being within the relationship. It is the order of the court or the sentence of the court that you serve a term of probation with the identical and not duplicative conditions. So you don't have to pay the fees twice. You don't have to do anything in addition to, it's all the same terms and conditions. There are no sentencing guideline recommendations for that count, and I am going to strike the condition that you pay an additional state cost. It's under the same case as this, so you don't have to do that. So those are the conditions of your probation. Sir, if you were to serve half your probation and complete the required programming, you might be eligible for early discharge. That would require potentially a court hearing, but you or your probation agent can file the paperwork, and I would review that. The other part is that Mr. Coyle is going to hand you a form that's in the podium there, the appellate rights form. If you wish to appeal what's happened here today, you may do so by filing an application for leave. You have to ask the Court of Appeals permission. The important thing about that form is that it's got your timelines and deadlines and all the important information. But specifically today, if you wanted court-appointed counsel to represent you for that appeal and you couldn't afford it, you have to make that request in writing within 42 days of today's date. Do you have any questions for me?
No, sir.
Do you know who your field agent is?
Yes.
All right. So Agent Pollard, does he need to go downstairs or he just needs to follow us?
Yes, he does. The name is. Will not be.
Oh,
Okay. So you're going to go down to probation in the basement here, leave your contact information, and your field agent will reach out to you to set up first contact.
I was just gonna say, I'll do that with him.
Okay.
This is most important. Did you give 2 5?
5.
Thank you. Nothing else.
Thank you. Good luck, sir.
May I approach with the order of dismissing counts?
Oh, yes, yeah.
We, of course, have no objection to those counts being dismissed.
So I'll just place on the record that I am signing the order dismissing counts 1, 2, and 3. Now we'll go in the file too. All right,
Thank you.
Number 10, People versus Christopher Gilmore, 2489 FH.
Yeah, Jonathan, on behalf of the people.
Jeanette Hood appearing on behalf of Mr. Gilmore, who's present by Zoom from the Washington County Jail. Mr. Gilmore, can you have someone unmute so you can state your name?
Good afternoon, Your Honor. Good afternoon, Mr. Moore. Good afternoon, Mr. Edmonds. Christopher Gilmore, Your Honor.
Okay, can you hear us, Mr. Gilmore?
Yes, Your Honor.
Time set for a bond violation hearing. Counsel, do we have any resolution to this, or what are we going to do today?
So I think we would like to approach, I just want to make a record that Regina, the complaining witness in this case, did reach out to me last week with a sense of urgency before he was arraigned on the bond violation to explain to me what occurred. At that point in time, she indicated that she did not want him to be picked up, that she did not want him remanded, that she wanted to have contact with him, and that she was upset that he was taken into custody as an officer of the court. I'm just reporting what she's communicated to me, and I believe that is still her position today. But if we can approach to discuss some related matters, but what Mr. Emmons and I talked about earlier.
Come on up. Let the record reflect a bench conference with counsel for the defendant as well as the prosecutor. Some discussion of the nature of the violation, kind of talking about the proximity of today's date with the current bench trial date of July 9th. So Mr. Gilmore,
Yes, Your Honor.
I gotta ask if you understand a couple things. One is you understand, right, that you are to have no contact with the complaining witness in this case, right? Like none.
Yeah. Yes, Your Honor. Yes.
So just so you know, though, if she's not prohibited from calling you, like she's not getting in trouble, right?
Yes, Your Honor.
But you're sitting in jail right now because she called you allegedly and asked you to meet her at McDonald's, and you did that, right?
No, I actually met her at her aunt, Your Honor. But yeah, I mean, yeah, it was like close in the proximity. It was in exclusion zone, Your Honor.
Right. So, but that was at her request, right?
Yes, Your Honor.
Right. So the illustration as you're experiencing, though, is that I'm not restricting her from anything. But where are you? You're in jail because you violated the bond. So I don't care how much she begs you to meet her. If you can't guarantee to yourself that you're not going to be in contact with her, i.e. if you need to deal with your children, which fair point, I get it, but you might have to have a third party or a neighbor or a family member help you with that, because if you are in contact with the victim, the complaining witness in this case, you are going to remain in jail for a long time. You understand that?
I totally understand, Your Honor.
So your attorney at the bench made a pretty vigorous argument that I let you out today. And the prosecutor is requesting that I keep you in custody until that trial on July 9th. I got to tell you about July 9th. A lot of times other things come up and I have to move my schedule around. So while my plan is to go ahead with the trial on July 9th, it is as likely as not that another type of hearing could come up that day. An emergency could come up that day, and we might have to adjourn your trial out a couple of weeks or months. You understand that?
I told you, yes, Your Honor.
So here's the deal. If I let you out today and there's any further contact with this victim or the witness, the complaining witness, you're going back into jail and we won't have this conversation again. Do you understand that? Like there's no question, I'll put it on the record right now, you will remain in custody until whatever day and time your trial is. You got that?
Totally, Your Honor. I totally get it, Your Honor.
Okay, so I don't care if she calls you and house is on fire, you got to send somebody else. You got to get somebody else to go with you so that you're not in contact with her. You can get your kids and see your kids and help your kids, but it can't be you and she exchanging them. And I also have to tell you that I don't know what all the facts of this case are. If it's going to be a bench trial, though, you know, a lot of times defendants bank on or assume that the complaining witness is not going to show up on the day of trial. And that just means that the prosecutor is going to dismiss this case. And my experience has been both with bench trials and jury trials that it doesn't always require the victim to prove the case. So it's not necessarily a guarantee. So hypothetically speaking, if she calls you and says, you know what, Christopher, I'm not going to show up on the day of trial, you can do whatever you want, and the day of trial rolls around and she's not here and the people have the officer in charge and other witnesses and they want to go forward with it, it is as likely or not that we're going to go forward. You understand that, right?
Yes, Your Honor, totally.
Okay. I've kind of reported what our bench conference was. Counsel, either of you want to put anything on the record right now, or are you good?
I don't have anything further, Your Honor. Thank you.
Nothing for me. Thank you.
All right. This time, then, I will order your release from the Washington County Jail on personal recognizance. So at this point, you are to be released. I'm not making any changes to the trial date at this time. So if nothing else changes, we'll go ahead on the 9th of July. Is that at 1:30 or 9?
I believe it was 1:30.
I think it's 1:30.
Let me check my paper planner.
I'm just gonna wait and have you correct. Okay, 1:30. We have confirmation. All right, so I'll see you back here on the 9th at 1:30. Sir, I you know, again, this is not a personal thing for me, like, man, Christopher Gilmore is not obeying my court orders. This is kind of self-preservation for you. because I am gonna enforce my orders. Community Corrections is gonna enforce my orders. The Sheriff's Department's gonna enforce my orders, and it's gonna happen. So if there's a violation, we'll have the hearing because I'm obligated to do that, but I'm telling you what's going to happen. You're not getting out of jail again. You understand that?
Totally, Your Honor.
Okay.
Your Honor, just one last thing though, since he's being released, if there, I recognize that if there's gonna have to be childcare issues, that for now, they're gonna have to arrange that through a third party.
It cannot be through the two of them. I mean, I can't restrict her from doing anything, but I can sure restrict you. So if you get a call from her, you should be hanging up because that's contact. And if she later gets angry with you and reports that you were on the phone with her for 10 minutes, those records exist, right? You know that. We could look at that. So that 10 minutes, that 1 minute, that 30 seconds could be a violation. So I'm just telling you, that's where we are. Okay?
Yes, Your Honor.
All right. Thank you.
Thank you, Judge. Mr. Gilmore, as soon as you're released, please call me.
Thank you so much, Your Honor. Thank you, Ms. Moore.
Okay.
Number 23, People versus Trevor Lyons.